Bismillah ar-Rahman ar-Rahim. Mr. Justice Sadduq Hussain Jilani, former Chief Justice of Pakistan, my brother judges, members of bar associations, worthy chairman ex-cjp, stakeholders, organizers, Assalamu alaikum. It is a matter of great honor for me to attend this symposium, which was, of course, the need of the hour, just for the purpose of streamlining our goals as far as our economy is concerned. Maybe reforms, supervision, or guidelines, whatever you may call. It is true that some burden is placed on the judiciary as far as such economy issues are concerned. But we all agree that we, as a member of the judiciary, have to interpret the law according to the Constitution and whatever the legislature have given to us. So far our supervisory role is concerned, that is only to watch the executives and others whether they are acting in accordance with the Constitution or not. But the policies have to be laid down by the executives for the purpose of smooth and modern running of the economy in a country. I have been working as a judge, as a company judge, when I used to be the judge in Balochistan High Court. Some experience I've gained over there, and I can share with you people that as far as the company laws are concerned, maybe it is 1913, 1984 or the current one. You can always notify certain flaws over there. In as much as we have noticed that merely for the purpose of instituting false litigation, the proceedings are brought before the courts, lingered on, with the result that the companies receive the setbacks. At that stage, as far as the judges are concerned, they can exercise their jurisdiction by dismissing the frivolous litigation, but once the process has set, it takes long time, particularly relating to the winding up. And restriction imposed upon the judges to dispose of the case within the period of 90 days, or within period of the 60 days, or within 120 days, it is never met. Because it is not possible. The judges of the High Court who head the benches, they have to also work on in respect of other issues as well. And when there is a lot of burden, they don't give the much importance to the cases such like the company's case, and particularly with reference to the winding up proceedings. As my younger Mr. Umar was telling, that we are probably here in Islamabad trying to meet the criteria, whatever, but I can differ with him that once the winding up proceeding starts, until the And when the assets of a company are disposed of or auctioned, at the end of the day, it takes years, 2 years together. And in the meanwhile, as far as the assets of the company are concerned, those are reduced to so much low value that you have to sell the same at the throwaway prices. Therefore, we have to think over it. As far as economy is concerned, if there is no best economic activities in the country, it is not possible for the state to run. Why we generate revenues, why we run after the money for the purpose of the running of the state. And if the state is not getting the better results, maybe from the executive institutions, or I would also say maybe from the courts, in that situation it creates then problem for the purpose of the state, because in absence of the revenues, it is not possible. However, as far as the attitude of the courts are concerned, the courts had been helping, paving way by having a pragmatic approach for the purpose of satisfying the requirement by giving interpretation to the different laws according to the Constitution and whatever the law is on the subject. But at the end of the day, as far as executives are concerned, they are also equally responsible for the same. And another important issue which has to be taken into consideration for a viable economy is that is stability and the rule of law in the country. If there is no political stability, say there is no rule of law, the court remain busy some other works, and they don't take interest or give preference to the cases like company judge or etc. Therefore, my suggestion was or is that there must be separate benches allocated not from the present strength of the High Court judges, or there must be additional strength which should be allocated to each High Court, even if need be by amending the Constitution. So they can only look after to the work which has been assigned to them under the Companies Act, Companies Law, or any other laws. I may point out here that previously in the repeal law of 1984 ordinance, there was a provision under section 9 which provided that at some time the government by notification can give powers to the district judges for the purpose of the civil judges or the civil courts for the purpose of doing or taking the decision in respect of the company cases. But in the present list law, when this section 6 has been promulgated, there is no such provision. In my opinion, as far as those provisions are concerned, those were very beneficial, and though in order to coop up, because Umar has given the example of Islamabad. I believe that now there are so many other cases, maybe Mr. Learned Counsel from the Karachi High Court may be pointing out, so many cases pending in the Karachi High Court, Mr. Sadat will tell us, that which are not decided within the stipulated period. In as much as I am of the opinion that let some situation be created where we can recruit lawyers for the purpose of disposal of the company judges within the period which has been prescribed under the law. But it is not being taken seriously. As a result whereof, that so far that aspects of the economy is concerned, probably that is not so much encouraging or giving the result as it should be. Yes, one thing is very important in the present section 5 of this 2017, wherein registrars have been given some administrative or ministerial work, and they have been allowed also to work under the regime, digital regime, under the IT, etc. But this could have also been further improved by extending the e-court system or e-paper system for the purpose of at least the company judges, so to save the time. Because the object is that there must be some positive result. If the winding up has to take place, it must take place within the period of the 120 as now has been prescribed under section 6. Otherwise, if it is not to be, then person should be given reply that this is not possible, therefore we are not going to winding up. As far as the merger or other issues are concerned, those are not of the much importance. As far as winding up is concerned, this is one of the most important issue which we have to face while filing the petition in the courts. And when there is such an atmosphere where we can cope up with all these such a situation, then of course it is very easy to decide the cases. Look, what is the experience? If the winding up order is passed, liquidator is appointed, statement of facts is taken from the company's directors, and thereafter it takes long time to determine the secured debts, unsecured debts, what is the position of the property, how that property can be disposed of, how the auction will take, when auction will take, then how much we can fetch the amount, and what would be the result at the end of the day, whether these funds would be sufficient to satisfy the claim, particularly those claims which are the secured claims. It takes more than 2 to 3 years. At the end of the day, the property, whatever we have taken into liquidator possession, that goes to be, he is bound to dispose of that at a very low price in the market. Therefore, it is necessary that all the stakeholders must sit down and think over it, that there should be some more expeditious procedure for the purpose of the disposal of such like cases. There is another important aspect that now under section right of appeal has been given. Previously under section 9 there was a right of appeal that if the value or paid up capital value is more than 1 million, then of course the appeal would lie before the Honorable Supreme Court. But now this time, in all the cases, they have said that so far the appeal is concerned, appeal would only be competent with the leave. But no, respectfully saying, but no criteria has been prescribed that why, under what circumstances, as under Article 185, Sub-Article 3, if we go in the court and the court asks us, that, sir, what is the point? Is there any legal point involved? And if legal point is involved, then the leave is granted. But here the law is quite silent. Law doesn't say that what should be the criteria and why the leave should be given that for that purpose. And therefore, I think that as far as the granting of the leave is concerned, it is very important. And while considering it, there must be some criteria. Otherwise, there will be injustice to the people, and maybe those persons who are sufferers are the creditors. Similarly, if the appeal right is not very much clear, as I suggested, then after the process of the winding up, if someone is ready and willing to say that let this institution function, we would be in a position to discharge our burden in the meanwhile. But normally the courts don't agree. The courts say otherwise, though the principle of the law has been discussed by the Supreme Court in so many cases, that no, in such like cases, there must be a distinction between the running and or the non-running institution. If the institution or the company, if the company is running one, why should we wound up it? And you can appoint, in one of the case, this was decided, that was in Hala spinning case, that as far as the board is concerned, board can be constituted and board can run this. It is not necessary that in every case we should wound up, and as far as the company is concerned, company must face the losses. A few principles have been laid down in that Hala case. I would like to point out those. That was that whenever a case of winding up of a running company is placed before a company judge or the appellate court, they should examine the matter differently from a company which is not in a running condition. There must be distinction. Efforts should be made by the judicial forums to adopt such a device so the project may continue running commercially and its financial liabilities start reducing gradually. Again, this was a case of the winding up, and the allegation was that as far as the company is concerned, company has gone into default. Next was 3. The business trend in the market is that if a running concern is put for sale, it fetches a higher price for its assets, which can substantially clear the proportionate liability of creditors. And besides this, there is another principle, that was that if the company contends that it is not liable to creditor and can satisfy the court that it has substantial and reasonable defense to plead, the court must hold that it is not in default and refuse to make a winding up order. I think such like principles and so many others which have been laid down by the Apex Code must have been considered by the lawmakers at the time of the promulgation of this Act 2017. And even now, through this forum, if possible, this can be achieved either directly approaching to the concerned departments who are responsible to look after the affairs, economic affairs of this country, or suggestions whichever we will be inshallah getting from this symposium be sent to the Law Commission of Pakistan for the purpose of considering the commission, and the commission, if is satisfied, particularly in respect of those principles which the Supreme Court itself has laid down, can make the recommendations to the government, to the legislation for the purpose of promulgating the relevant laws or making amendment, because the law should be such like that it should not cause loss to anybody. If possible, the project should be saved and let it continue, so as far as liability is concerned, it may discharge its liabilities. There are so many other questions besides Section 5, Section 6. As I pointed out, Section 5 is a good addition. The registrars now will be having the powers and may, when the case is matured and ready for arguments, we will be put up before them. But before the court of jurisdiction, but at the same time, some further substantial reforms on the basis of the discussions or the decisions of the courts are to be made in the substantial provision of the law. And as far as the winding up or merger or other issues are concerned, of course it is a subject which takes time. It is not possible to finish it up within 1 or 2 sittings or within 2 or 3 such like seminars. You have to continue such like exercise in the interest of the public funds, in the interest of public, and the interest of this country as well as the industry, and in order to ensure that its economy grows actively, so this country or the state may get the due revenues for the purpose of its running. Otherwise, it becomes very difficult for the purpose if there is no funds or no revenue are collected by any means. Thank you very much.